really great to be here. To return to the Weizenbaum Institutes. It's really excited about it. Always a stimulating place of good conversations. And today I'd like to talk about scraping, more specifically about scraping legal battles. And that is something that has shaped the technology of the internet, and it's really interesting to sort of visit nowadays as we are in times of transition to a new type of technology that is mediating our conversation and the accumulation of knowledge. And so scraping was, I think, one of the first scraping cases was about 25 years ago, the year 2000, right? When we had a lawsuit by a small search aggregator, Bidder's Edge, against an upcoming auction site, eBay, that successfully prevented the scraping of that of its website, and from then on we had lots of other cases of scraping, including Google, etc. All of them using technology generally defined as any automated collection of data from user-facing interfaces. Of course, you can use other definitions, but I think what is common to all these scraping disputes that we will discuss today is that they use some type of automated script. They target the extraction of data in some systemic way, and they sort of produce or generate some structured output. And it could be done in an industrial manner, such as scraping that is done by the crawlers of Google in order to index the internet, but it could also be user-driven fetching, scraping the type of scraping that is done by companies like Bright Data and others. Advantages are obvious. It's more efficient to scrape rather than do it by hand, more accurate, it's scalable, of course, and it, of course, has natural advantages for research oversight and innovation. I'll discuss it later. What we have now in the new generation of scraping legal battles is scraping that is intended to facilitate some sort of data-driven products, apps. So one of the first in this new generation of scraping battles were the LinkedIn lawsuit brought against HiQ, a small startup company that was harvesting, scraping personal information that was made available by users of LinkedIn in order to develop some added value apps that could be, or services that could be sold to employers. We had some battles related to scraping around research, where companies like Twitter, now X, Meta, and others were cutting off researchers that were doing scraping for the purpose of research. We had, more recently, last year, two big lawsuits in the US brought by X and Meta against Bright Data. I will talk about this later. And very recently, a new bunch of lawsuits that are brought against Perplexity AI by right holders such as Dow Jones, New York Times, Britannica, but also Reddit, interestingly enough, that is hosting some materials, postings prepared by users. Basically, in these lawsuits, we have two competing views of scraping. And the plaintiffs are usually claiming a breach of contract, copyright infringement, violation of the privacy of users that are using these websites, unauthorized access, either under the anti-circumvention legislation in Europe or in the US, or under some computer fraud laws that prevent hacking. Overall, plaintiffs usually claim that there is some commercial harm that is involved in scraping, and that the use of the data in this way is misappropriation, unjust enrichment, some sort of claim for the commercial harm. Defendants, on the other hand, in all these cases, are claiming that the contractual restrictions should not be enforceable, that the use of copyright is not non-infringing because it's a non-expressive use or fair use or exempted in some way under the law. And overall, they claim that they're protecting the rights of users to access publicly available data. I think that is actually the key. And I think that what makes these cases really interesting in this moment in the development of the technology, that where we are actually seeing these battles in time of transition, where we are facing this disruption by those LLMs and AI agents that enable a different type of engagement with data, a different type of exchange with data that is hosted and possessed by others, synthesis of data through new types of intermediaries like LLMs, which probably bring into question some of the ways in which we viewed these battles over the past 25 years. So in terms of overview, what I'd like to do is to first dig in a little bit into the legal disputes and look at three issues. And the reason I want to dig into the legal disputes, not because I want this talk to be legalized, but because I think that there is much to learn from the disputes on what's at stake for the parties, but also what type of barriers we're facing now when we think about scraping or accessing data using these automated tools nowadays. And so we'll look at some contractual barriers, some technological dimensions that are supporting these contractual barriers, and how the use of these barriers is also affecting some of the copyright analysis in these battles. Then I'll talk about some policy challenges, and we'll share some concluding thoughts. So contracts. Contracts actually have been taking the front seat in a lot of these disputes. And the reason is that in a lot of these scraping disputes, there is no property right or copyright in data. And so we have no copyright in data because raw data is sort of discovered. To the extent that data is protected, it has some only limited rights in compilation, the way it is being organized. Of course, the database protection that is provided in the EU is a type of an exception, but it's not really relevant to what we are discussing. It has never been claimed in the context of scraping dispute as much as I know. We don't protect data, not by accident, but because it is considered around the world as a big building block for further creation. And so one of the purposes of this legal regime of of copyright is that some protection to works is granted in order to enable the public to access some of the data that is embedded in these creative works, so that it can, the public, general public, can engage in further creation. And so no ownership in platform data, and therefore the way to actually protect against the use of the data is through the contracts. And so we have in contracts provisions like this, as you can see from LinkedIn. So no scraping, no copying, no extraction of data. Users agree not to access, scrape, crawl, or spider as a service or any related information using bots or any automated methods. You have very similar contracts, terms of use restrictions in the standard terms of service of X. And in fact, you have very similar restrictions in the few hundreds platforms that we study in an empirical study that we did actually using a bunch of research assistants that were actually analyzing a couple of hundred terms of use of platforms over a period of 10 years, looking in two milestones in 2012 and 2022, where we were actually looking at the restrictions over access to data for research purposes. And what we've seen is two types of restrictions, an enormous increase in restrictions on access to data. So direct restrictions such as no automated data collection, no data collection at all, but also indirect restrictions such as the permission requirements that you really need to log in. And therefore, if you're a third party, you cannot do any research according to the contract that involve this type of scraping. So a lot of restrictions on access to data by third parties, and at the same time, a lot of provisions that are facilitating access to data only by the platforms. So no third parties can use the data, but platform actually acquire the rights to use the data for research purposes and for everything else. That is, by the way, a side effect of the GDPR, speaking about the impact of regulation. That is what we have seen. This is a picture that we have seen in the terms of use of platforms. So this combination of facilitating restrictions, of facilitating provisions that enable platform to use data without any limits on the one hand, and restricting any third party from using that data that is generated by users. We call this the enclosure of data by private ordering, of course, building on the work by Professor Jamie Boyle that actually analogize the enclosure of the public domain using private ordering, such as contracts and technological means, to the fencing of land in 18th century England, where people were sort of taking the commons, but fencing the land and making it their own simply by using the means of excluding others. So how does copyright law actually interact with these contractual restrictions? And here I want to talk a little bit about American law and then look at European law. So in the United States, there is actually division of labor between copyright law and contract law. So if you try to use state law, including contract law, in order to govern the use of copyrighted works, in this case, data. Even though data is not protected, it is covered by copyright law, so it's a copyrightable subject matter that copyright law left in the public domain. As long as this subject matter come within the matter of copyright law and try to create a right that is equivalent to the rights that are created by copyright law, then copyright law take priority. And in other words, what governs the use of that data is copyright law rather than the contractual restrictions. This hasn't been the case in the past. So preemption doctrine has always been part of American copyright law, but until recently, it was narrowly defined or narrowly interpreted by courts. And a good example is a Pro CD case. You see that this is from the 90s. But this is, again, a case of using massive amount of data. Here it was telephone directories that Pro CD is copying from Yellow Pages and turn it into a searchable CDs of phone numbers. Now, telephone listings are not protected by copyright law. Pro CD created this package that you could buy in the store. And then Zeidenberg, the defendant in that case, has taken this, this beautiful selection of CDs and uploaded all the telephone numbers to the internet and connected it with his own search program. And so Pro CD is bringing this lawsuit to the court saying, we know that there is no copyright infringement, but it is violating our terms of service, our contract. And the court said, yeah, it looks like you have a good contract claim. You can actually claim that this is a breach of contract. But why? Because copyright and contracts are actually playing in two different worlds. Copyright creates a right against the world. This is a proprietary right. Whereas contract is only affecting the party to that contract. Even though in these boilerplate contracts, it actually affected everyone that would touch the CD, right? But this was the interpretation of the court, and that was a prevailing approach of courts in the United States until very recently. And it's interesting, right? So this is what we see during the time of the 25 years of internet time, web access times, and now more recently we see the winds are changing in America. So first case is Genius. So Genius is a storing website that is hosting lyrics, copyrighted lyrics. Google is, of course, trolling the lyrics, indexing it, and linking to it in the search results. Genius bring this lawsuit for scraping, claiming that this is a breach of contract. And the court said, no, you can't do that, because what you are trying to do is actually to protect songs that do not belong to you, belong to your users. And if the users are upset about that, they can bring the lawsuit. You cannot prevent the scraping of songs that are copyright protected by simply relying on these contract claims. A very similar result we see in last year litigation between X and Bright Data. So Bright Data is actually an interesting scraper because it's a user fetching scraper. So the user wants to scrape something. They have a research question, like a market question, like a market, they want to do market research. They want to know what their competitors are. Or they work in a university and they have some research questions related to what X is doing with respect to content moderation. Now, tweets on X belong to the tweeters, right? To those who actually post the tweets. So copyright belongs to them, but they give X a non-exclusive license to use it. Otherwise, X cannot actually distribute and share it. In the terms of use, I showed you before, the X, like all other platforms, are actually including a no scraping restriction. So right at a scrape, X bring this lawsuit, and the court is saying, listen, a non-exclusive license, you're not the copyright owners. Your non-exclusive license does not enable you to prevent third parties from copying, from scraping these tweets. What is really interesting here, and I think very relevant to the theme that we are seeing today, the way in which platforms are trying to sort of misuse the, some of the powers that are given to them. What the court is saying, they say X is trying to enjoy both worlds. On the one hand, to say, we're not the owner of the copyrighted materials. They belong to the people who actually posted these tweets. And the reason they do it is because they want to sustain their status as intermediaries, because they don't want to be liable for whatever harmful tweets were actually shared on Twitter, right? So under the DMCA in the US and the e-commerce here and the DSA in Europe, they cannot, they don't want to actually own everything that we share on X. On the other hand, with the non-exclusive license, they're trying to actually extract some control regarding third parties. The court did not allow this. And the court is also holding something that is really interesting and important, and that is that enforcing the bans on these contracts would actually compromise and undermine copyright policy, because copyright meant to leave this data in the public domain, the data that is extracted, that is learned through the scraping. And if we allow X to prevent this type of extracting of data, actually we will compromise the purpose, the goals of copyright law. When X was trying to actually claim that they were protecting the privacy of their users, the court was skeptical as well, saying, well, you, again, are really worried about the personal data that belong to your users, but you don't care about sharing that data if you get paid, and therefore you are not the right plaintiff for that. So in other words, if a user of X is actually claiming privacy violation, or in Europe, violation of its rights for personal data, then it would be a different story. But X or any other hosting facility is not the right plaintiff for that. Technological measures also play a role, and here sometimes it's complementing contracts, so whatever is written in the contract is also protected through technological measures. And very interesting development just from the past couple of months was the announcement by Cloudflare that Cloudflare usually is a web security company that is responsible for antivirus implementation and the traffic of bots. Cloudflare announced that it would enable websites to prevent scraping unless it is authorized, or in other words, facilitate pay-per-scrape business model, thereby allowing the streamlining of scraping permission requests. The next thing we know is that scraping companies were actually publishing ways to circumvent or bypass this type of new technological measure. And of course, Cloudflare now is threatening a lawsuit for this bypass. So what Cloudflare calls steel scrolling, you see companies like Perplexity that is facilitating this, claiming this is simply web users trying to exercise their right to access publicly available data without requiring the human itself to actually interact with the website. So what we see in this context is, of course, a technological race, unless we'll see a court intervention that would say, you cannot do that. You cannot either circumvent whatever Cloudflare puts in place, or you could not interfere with the right of stakeholders or users to actually surf web-facing, user-facing websites without any interference. Just before we go into the policy challenges, to say very quickly how it affects copyright. And the reason copyright becomes really important nowadays is because it is being claimed by right holders, but also by hosting facilities as a reason for not allowing scraping in order to enable the harvesting of data for the purpose of training LLMs. So scraping itself would easily become a copyright infringement just because it involves a lot of reproductions, right? Copyright is about copying. Copying without authorization is a copyright infringement unless it is authorized by the copyright owner, like Cloudflare is now proposing, or it is exempted by law. And here we have two exemptions that are important to discuss, and that is the fair use in the US and the text and data mining in Europe. Both of these, and this is the reason that I mention it, both of these are actually affected to some extent by the question of whether permission was given or denied for scraping. So quickly look at the US. This is really very brief. So in the US, we have fair use. It requires court, when they consider whether a use like scraping was fair, to consider the purpose and character of the use, especially whether it was transformative or whether it used the same purpose of the original work, to consider the nature of the copyrighted work, whether it is the work within the core of protection in copyright, music, text, original paintings, or whether it's something with copyright does not protect, like data. The amount that has been copied in scraping mostly will see the full amount. Everything is being copied in order to extract the relevant data. And then the effect on the market. These are the Google cases, the big cases that we had a decade ago, were actually in the US deciding that this type of massive scraping is fair use. Massive scraping for the in this lawsuit of Authors Guild against Happy Trust. This is the data set that was digitizing millions of books, providing this searchable data set of full text to universities. Court said in general, this copying even though it's on massive scale, it was transformative. It serves a different purpose, the purpose of searching, and therefore it is transformative, and the same also for the Google Book project. But we know that this is a litigation that took place for almost 10 years, from the beginning of 2000 till 2015, and ended up with a win for the Google scraper. So the question here, of course, how does this affect the scraping of Gen AI, of data for the training of LLM? So in general, we think of learning as fair use, and the question is whether the same would hold for training data. And what we see, and this is interesting, is that at least the two first decisions that are coming out from American courts are saying generally, this is not really scraping, but it's massive copying of books in these two cases. So this is book authors against Anthropic that was using books for the training of Claude. 3 instances. First is the use of book as a training data for the LLM. The court is saying this is transformative use. This is a core of transformative use, and there is no harm because book authors are not entitled for this type of benefit or profit that they can sell their books, right? If you copy their books, then it's a copyright infringement. But the extra knowledge that is in data that is being extracted related to the patterns of language, for instance, from this data is not part of the expectation, the reasonable expectation of authors. So this is a first instance that is being discussed in this case. The second instance is simply just the digitization and storage of purchased books. So you buy a bunch of books and you digitize them. You create a copy in a database for training. Here, the court is also saying these are paid copies. You bought the copy. You can extract the data in order to train. What is more into, goes into what we are, the point that we are discussing here, that if you are downloading and storing a collection of pirated books, then it's not fair use, the court held. And as you may have heard, Anthropic settled for a very large amount of money. So if it is not permitted, of its pirated books, so these are books where access to the books was not lawful, then maybe it's not fair use. In a similar litigation, again, the authors of books against Meta for the use of books to train Llama. The court is saying it's highly transformative, and the fact that the books were pirated does not move the needle, meaning that if it's transformative, it's fair use. Who cares whether this was pirated or not? So in these two cases, we are left with some uncertainty regarding the significance of the question of whether the access to the original work was lawful or not. And I think in the United States, we'll see how this evolves. In Europe, you know better than I, there is the text and data mining exemption. And here, the text and data mining, interestingly enough, is really defined broadly to cover the same mechanisms that are being used or applied in scraping. So scraping is an automated analytic technique for collecting the data and then analyzing it in order to extract the patterns. Right? And so the question is whether this will be exempted or not. And of course, with these exceptions, we have two. One for scientific research, where the exception for research is mandatory. You need to be a research organization or cultural heritage organization, but still you need to have some lawful access to the work, meaning that if it wasn't lawful, maybe you cannot enjoy the exemption. Even worse, when we talk about the general purpose exception, where reproduction not only has to be from lawfully accessible works, but the owner of the work can also opt out if any contract, and these contracts is what I've shown you before. So where does it leave us? So we see that we have contractual and technological barriers that are affecting the practices of web scraping, at least the legality of them. And they also affect some of the copyright claims or the ability to exercise or to rely on some of the exemptions in these laws. If we zoom out and we try to understand what the implications are, we actually look at two types of plaintiffs in this arena. We have hosting facilities that are bringing these lawsuits against scrapers, and we have right holders. With the hosting facilities, I guess what we are seeing, which is a really interesting phenomenon, not unexpectedly, what we see is that platforms' objectives may not necessarily align with the broader interest of users. Now, one can say, well, sometimes it does, right? I mean, sometimes users don't want their content to be scraped. But think about this case, which is a lawsuit from last week, right? Where Amazon is bringing this lawsuit against Perplexity AI again for using AI agents that would interact on the platform, again, engaging in some sort of scraping at all levels. That level could be the information gathering, just to know tomorrow is Black Friday, right? You don't want to go into all these websites. You just want to send your agents to chat and to avoid some misrepresentation, maybe. You want to sometimes also hold on negotiation on the website on your behalf, and sometimes maybe even to get the bargain and conclude the bargain, avoiding any type of personalized pricing. There is significance here in sometimes hiding the identity of the actual consumer. And so there are lots of added values for the user, but not necessarily for the platform. And so we see that these interests are not necessarily aligned. What we also see is that platform objectives may not align with the public interest. And that is true for the scraping that enables comparative analytics. So comparing the prices, but also comparing the approach of each of every platform, Reddit, Twitter, X, Amazon, to particular issues. How do they manage the data? You can do it by scraping, you can do it otherwise. And of course, some control that is not restrained could prevent scientific research that enable to sort of learn extra knowledge from the simple analysis of data that is publicly available and is accumulated by platforms. It also affects potentially competition. I mean, one of the issues that we're concerned about is consolidation of the market. We don't want those who have the data to be the only ones that can actually now develop the LLM. So platforms do have the data. They control it. They can train on YouTube, on Google, different services, and we may think it would be better to have a more competitive landscape for innovation. Who says that LinkedIn is the best for developing the new generation of apps that would help employers and employees in the labor market? And the final issue here related to the policy considerations is, of course, the oversight and accountability. If we want to learn what hosting facilities are doing, we need to enable some research. And so in Europe, you have the DSA that had a very limited and narrow approach, allowing the scraping only by vetted researchers. But the question is whether organizations such as some NGOs in the US that wanted to learn things about what Twitter at that time was doing could use scraping in order to do that without getting permission, not from the platform, but also not from the government. What I think is even more important is to think beyond the status quo. I mean, we're looking at hosting facilities. Why do we protect their rights? I mean, what is we are trying to protect here? What is the essence of the scraping threat is actually on the relationship that web-facing services were having with their users. And so users using user-generated works are attracting other users. All of them becomes a subject of surveillance that collect data that is being sold by the platform or sold to advertiser, or the attention of these users is being sold to advertisers. And one of the questions related to the harm or commercial harm that we view in scraping is whether we should protect and sustain this model that was under a lot of attack and criticism over the past couple of years, that this is not a good way of accessing data. This is not a good way of engaging with data and of accumulating and creating knowledge, news, and scientific results. What about right holders? Here too, I think there are some interesting policy challenges, and that is, should websites that actually represent owners like New York Times or Dow Jones have a right to prevent circumvention of paper crawl like Cloudflare? It's a huge question. I think the alternative would be to leave it for the technological race. But this was a question that we faced in the 90s when we were discussing circumvention, right? The anti-circumvention legislation. Is this too much protection? And if we put it in place, or right holders, how do we ensure access to data in such environment? What should be the default here? But I think the more interesting question is whether we can imagine new models of content monetization that would enable some sort of compensation to right holders that are not web-facing access, right? Why do we think this is the only way? We actually, during the 90s, right holders, copyright right holders were saying the internet is undermining our business model. Now they say it again, but this is after they moved into the internet business model. Maybe they can have another model. I mean, one can envision, for instance, a model where you actually put your content and people can extract all sorts of output for a type of fee. That could also be a business model. I mean, we don't need to look at web-facing, user-facing web access as the only business model all of a sudden, just because it's there. In terms of policy, and I want to stop in a minute, just in order to allow for more questions, but just to say that there are in policy we have like in legal policy we have like big challenges of like reforming copyright law or changing a new strategy for the digital environment. But we could also have like legal reform, like the one that I've described to you that was done by US courts. And I think here we talk about, I demonstrated to you how all of this is happening through private ordering so that it's self-help. But that relies on courts to enforce contracts or to prevent the use of technological measures. And so one can envision scraping enabling contract interpretation, where courts would say, like we've seen in the Genius case or in the Privat case, where courts were actually coming into interpretation that does not conclude that there is a violation of the contract or that there is fair use. Other cases, again, without going into the details, were where courts was narrowly interpreted anti-hacking laws in order to enable some sort of scraping. So saying that simply, if something is simply unauthorized by the contract, this is not hacking. Or that hacking laws would not apply to publicly available information. And finally, maybe we can think of something that is inspired by the DSA. So the Digital Service Act has, of course, this regime that is more like a sword, and an ability to require some data from platforms for vetted researchers. But there is also a shield where researchers should expect to have a right to publicly, to harvest, to scrape publicly available data. And maybe this could be extended for some duty of platforms not to interfere with such a right. I think the question is not necessarily what would be the details of what govern access to data, but more so who will define them, whether we will allow private ordering of this sort to get out of control. And what I would argue that there should be some limits in the law to what parties could do by fencing contractually or technologically their publicly available data from scrapers. And these are the papers on which this talk is based, and some of them are joint work with Mayan Pil and Ohad Solech. Thank you.